Emily, you rightly pointed out with regards to the financial thing that where we have been put like 15, 5 to 6 pages filling out all that information out. We never got a single denial on that issue, especially for the employment-based immigration. And we never, and Stephen pointed out, not even a single RFE on it either. Not a single RFE on it either. Yet we had to go through all the burden. It could be that, or we have like, for example, 60 days of grace period after the H-1B is let go. Um, and that is also discretionary relief, but we haven't seen any denials of people moving from company A to company B within 60 days. Of course, we have seen some reversals with regards to the B2 switching back to H-1B, but not from company A to company B. We haven't seen anything. It could be that way, or it could be drastic as getting all the 485 denies unless we show the extraordinary circumstances why they need it. And they could point out in the DS-160 form, and when you filled out, you said you came on F1 visa, then you changed to H1. You never left after F1, you never left after H1B, or they could deny. We don't know at this point of time. So, and Stephen pointed out that it's only 3-4 hours. We're banging our heads. What are they going to do about it? Now, what do we advise for people right now? And the questions that are coming here right now is, I'm filing my adjustment of status. I'm married to a U.S. citizen. What are the steps that I need to take? I'm about to travel. It's a summer vacation for me. I have an advance parole. I have to travel. I am an adjustment of status, and I have an EAD, but I don't have any non-immigrant visa. Okay, should I get back to H-1B? What are your answers, guys?
Those are a lot of tough questions to answer right now. I think, if I'm someone who's married a U.S. citizen and was planning to file the adjustment of status, as of this moment, I would probably still file it. I would maintain my non-immigrant status after filing. If you're in a situation where, for marriage to a U.S. citizen, you don't have to be in a non-immigrant status. You don't have to have any status to qualify to file. Might want to wait and see what happens there. I don't know how safe it's going to be to file a 485 in that situation. For someone, who's employment-based and traveling on advanced parole, is it safe to travel right now? Maybe not, because it's possible that your 485 could get denied when you're outside the U.S. and you don't have an advanced parole to come back on anymore. So you would want to have that non-immigrant status. So I think right now, the most conservative thing would be to maintain your non-immigrant status, don't travel, and then maybe cautiously proceed with the 485, maybe include some of the positive discretionary factors at the time of filing, and, hope for the best at this point. But yeah, I think it's risky to travel on AP now.
I don't know. One question. To your point, I definitely wouldn't not file for adjustment right now. I mean, I think definitely I would proceed full steam ahead with that, because, with the understanding that maybe there's a greater chance of denial. But no, and someone just asked, and let's be very clear on the terms of art we're using here. This is not a change of status. So this doesn't impact, going from your F1 to your H1, although, Emily, let's not talk about it. This memo is fully about adjustment of status to a lawful permanent residency for the green card. So we just had 2 people ask that on YouTube about, their H-1B cap cases. That's not what we're talking about. That's a change of status, adjustment of status for a green card. Very term of art.
So what you're telling, this is not applicable from people moving from H4 or F1 to H-1B. It does not affect at all. That's what Stephen said. One question, a lot of people saying, okay, so what? We're going to do consular processing. This question is coming from ASTICA 7103 from YouTube and other people. That, okay, we're going to do the consular processing. It's not that easy, guys, consular processing, because consular processing involves a lot of delay, a lot of discretion. You're outside the country and you may not If they do put it, if some query on your thing, you may have to wait for a long period of time. There's a lot of discretion that they can use in denying it the consular processing. So normal immigration lawyers are reluctant in sending the clients out there.
Yeah, and I would also add, the consulates don't have the capacity to handle everyone who would normally file for adjustment of status now doing consular processing for their immigrant visa. They don't even have the capacity to handle the current number of non-immigrant visa applicants because everyone requires an interview now. How are they possibly going to handle the number of people that would normally file a 485 at the consulate? It's just going to create a huge backlog where people are going to be, waiting in the US for their interview to be scheduled for years because the consulates do not have the capacity to handle that many more immigrant visa applicants.
It's funny because I'm looking here at X, an attorney friend of mine who tweeted out a textbook. It's an older textbook, but it talks about it. 1952, the idea, Congress enacted the INA to include this adjustment of status, because, why was it better for someone to leave when it could be done here in the United States? And Emily, you and I talked about this morning. I think DHS with, HSI with, all the petition, everything, they have more information with DHS, with USCIS of the immigrant's journey than the consulate has.
Yeah, I mean, for people who are in the US, H-1B holders, L-1 holders, but other visa applicants as well, most of them have had to file petitions with USCIS, file applications for USCIS, provide their information to USCIS over and over again so that they could be vetted. And so USCIS could determine whether these people qualify for the visa that they're getting. And now, so all of that data is within USCIS. And so we know when someone files a 485 that USCIS goes through that data. They use that information to determine whether you qualify or not. Department of State might not have access to all of that same data. So they're the ones that would be adjudicating a immigrant visa at the consulate. I feel like USCIS is in a much better position to actually vet green card applicants compared to the consulate who would be doing all of this from abroad. So I'm not sure how this makes us safer or more secure or eliminates fraud when the people that have the information aren't going to be the ones adjudicating the application.
And USCIS also has a better understanding of what's going on with all that. Department of State might see data points, might see numbers, might see parts of the petition, but I mean, USCIS has the institutional knowledge more so than Department of State. Let's take in, if there's past issues in an H-1B that is not an inadmissibility, but that Department of State would be looking at, that would be USCIS. So we'll see. How this goes in the next couple of little bit here.
So a couple of notes I made, Emily, that what we were been advising clients before and what we are telling right now is quite different, of course. So one thing is that what you said is maintain the non-immigrant status, which was not encouraged before by us, particularly me, Rahul Reddy. I would say that right now, until we know what's going on very clearly, if you are having a non-immigrant intent like H-1B or whatever status that you have, continue on that status instead of moving on to the EAD. That's one change for us, USC. The other change is that we told people that, it's completely safe for you to travel on advance parole. Now we are taking that back. We are telling people that don't travel on advance parole until we will see how the things will run. We'll update the things. And also those people who are already outside the country on advance parole I am advising them to come back into the United States as soon as possible, so that if there is any untoward action happens, it's better that we handle the things here in the United States. Now, people who have been on EAD, would I move them back to the non-immigrant status? Most probably no, because that may involve $100,000 fees, because we have to do the consular processing. And also the consular processing, the things are not good. We are not getting the appointment. We are getting the 221G. So I would not take that step of converting them back into non-immigrant visas. But those people who are already here on non-immigrant visas, I will tell them to continue on the non-immigrant visas. Am I correct, Stephen and Emily?
Yeah, I would 100% agree with all of that. Until we see how this is actually being implemented, we need to operate under the assumption that adjustment of status is not safe as a status, because it could be denied at any time. And so don't rely on your adjustment of status. Continue your non-immigrant status even after you file. Don't use the EAD. Don't travel right now. Don't use the AP. As you said, for people who've already switched and are relying on the adjustment of status and using the EAD, I think now is not the time to travel in order to get the non-immigrant status back, because that's more of a problem that's being created. But something to consider as we see how this is actually going to play out. We don't know how drastic USCIS adjudicators are going to be with this. Is it going to be like the 944 form adjudication, or are they going above and beyond that to deny all 485s unless there's just something incredibly extraordinary about the case? We don't know yet.
Yeah, and I think you nailed it, Emily. I mean, people like to think immigration lawyers fearmonger. And I would say in this case, it's being cautious and advising you to be cautious until we know. We have a memo that kind of changes decades of immigration, okay? Practice, principles, understandings, upends it in a memo, okay, that's released on Friday morning. So we don't really know how it's going to be implemented. And until we see trends, until we see guidance, until we see whatever, I agree. It's better to be cautious with travel, with abandoning your non-immigrant status, which again, I think is stupid. You should be able to. But it's better to be cautious until we know for sure.
I'm responding to Regiland. Can I extend the H-1B based on the I-140 approval? Yes, you can. This memo is not applicable to the extension of the H-1B based on the I-140 approval. You can still continue doing so. For the people who are about to file the adjustment of status right now, I will still advise them to file the adjustment of status, whether it's a family-based immigration, whether it's a employment-based immigration. As Emily has pointed out, I probably will try to collect the documentation that why you change the status, why is it you need the adjustment of status here instead of going to the consular processing. But I will still file the adjustment of status right now. Emily, what do you think?
Yeah, I agree with that. I think I would include the positive discretionary factors in the filing, but otherwise go ahead and file it. Just continue to maintain your non-immigrant status while we wait and see how this is actually going to play out.
Any litigation part, Stephen, on this?
I think it's being formulated. I've been talking with multiple lawyers this morning while I've been talking with folks while we've been on live. I mean, I think there's definitely things being formulated, and I think the tough part, and I think there's ways around it, is, finding plaintiffs with standing, because nobody's harmed yet, right? We have a memo, but nobody's harmed yet. Now, I think there's good arguments that there's imminent harm because of what we talked about at the beginning, and I think there's ways around it. But I think finding the right way to challenge it is going to be important. But I know, been texting with folks, talking to folks, tweeting with attorneys, emailing while we've been on here, that the wheels are turning. I think something will come. Might not be tomorrow, but I think it's in the works.
Anything else?
Nope. Let's see how this plays out. Unfortunately, we're in a wait and see mode, very similar to what we experienced with the $100,000 fee proclamation that happened on a Friday, and we saw how things adjusted over the weekend into the following week. So we'll have to do the same this time around.
Thank you very much for tuning.